Confidential sources are one of the most useful tools for a journalist and one of the most dangerous tools for a journalist. I guess the best advice that I can give to you is, if possible, try to limit or not use confidential sources. Hello, I'm Professor Harper, and welcome to another lecture for Journalism and the Law. So, confidential sources are covered in most states by what's called privilege. So journalists have, in most cases, qualified privilege. And you've probably seen this on a number of shows on television. What's called absolute privilege involves the relationship between a doctor and a patient, a lawyer and a client, or a confessor and a penitent, so that a doctor cannot be forced to testify against a patient in a trial. Same with a lawyer, same with a rabbi, priest, or minister. And a qualified privilege involves the relationship between a journalist and a confidential or anonymous source. And qualified means it does not prevent a prosecutor from calling a journalist to testify before a grand jury. So there is a history of privilege. 1855, the New York Times reporter was found in contempt of Congress for refusing to testify about a story that he wrote. He later testified. 1873, an editor for the New York Tribune was subpoenaed to appear before a New York grand jury. He refused and was found in civil contempt, which basically means he went to jail until he told his story or the judge changed the sentence. In 1959, in Garland v. Torrey, the U.S. Court of Appeals for the Second Court refused to exempt a reporter from testifying before a grand jury. Essentially, it said that a journalist is a citizen and that citizens need to testify before grand juries, and so therefore a journalist should be treated like a member of the public. Now, the big case was Brandsburg v. Hayes in 1972, and here the court decided by a close vote, 5-4, that the First Amendment does not provide journalists with the right to be free from testifying before grand juries about criminal activities. So what this case involved is that Brandsburg was a reporter for the Louisville Courier-Journal. He wrote about drug use in two separate instances. Paul Pappas was a newsman and photographer in Massachusetts that gained access to the Black Panthers. Earl Caldwell of the New York Times reported on the Black Panthers, and in each of these instances the prosecutors wanted these reporters to testify before a grand jury. These various cases were decided differently in the lower courts. Brandsburg and Pappas lost in the lower courts, and Caldwell won in the appeals court. But the U.S. Supreme Court took up the issue, and this remains one of the most significant restrictions on freedom of the press that the U.S. Supreme Court has ever made. So Justice White declared that the general obligation of a citizen is to appear before a grand jury or at a trial, which outweighs journalists' privilege claims. Essentially, as I said earlier, journalists have no rights that are greater than citizens. Justice Stewart dissented and provided a three-part test, which is still used, that 1, there needs to be probable cause that the reporter has the information. 2, that the information cannot be obtained in any other way. And 3, that there is a compelling and overriding interest in the information. Now, the prosecutor also has to determine on the federal level that it needs to put into place the type of proceeding in which the journalist must be forced to testify, the type of information, so that non-confidential information is almost impossible to protect, whether the individual is a journalist, and the U.S. Attorney General issued guidelines in 1973 that a prosecutor must not impair a reporter's responsibility to cover a story. So while the overriding decision by the U.S. Supreme Court was journalists must testify, otherwise they will be found guilty of civil contempt and they will go to jail until they choose to testify. There has been a little bit more leeway in terms of how journalists are forced to testify. Nearly all states in the U.S. and the District of Columbia have varying degree of qualified privilege for journalists. The Pennsylvania laws is rather strong. The protection varies, often does not cover freelancers and bloggers, and there is no protection when a journalist is being subpoenaed in a libel case against himself or herself. There are some other court cases that are important. Zurcher v. Stanford Daily in 1978, the court found that the police had conducted a legal search of the newspaper offices when it went out to find information that was in the newsroom. And the court determined that the Fourth Amendment are directed at places, not individuals. So therefore you could go into the newsroom and get information because it was a place. The Privacy Protection of 1980 was in reaction to limiting newsroom searches, and there were exemptions so that the only way that you can go into a newsroom is if a journalist is suspected of a crime, whether there is the potential of imminent death or serious injury, the possibility of destruction of documents, and also a failure to produce documents under other remedies. Sounds like my able assistant, Sid the Great Pyrenees, is up and well this morning. Thank you, Sid, for your bark out. There are some recent cases where journalists have been found in contempt for failing to provide the names of sources and information when asked to testify, so that Judith Miller refused to testify and went to jail in what is called the Valerie Plame leak. She was a CIA operative. Scooter Libby, who was an assistant to the vice president under George Bush, was indicted for providing information about the leak. The judge said journalists have to testify about who gave the information, and Judith Miller refused to do so. The Boston Globe decided to pay $1.68 million in a libel case rather than to reveal its sources. A variety of news organizations agreed to pay $750,000 to a Chinese scientist rather than to reveal the sources of information that he was an agent for the government of China. One that affects journalists as well is that Jeffrey Sterling was indicted under the Espionage Act of 1917, and he had given information to a journalist and was actually punished under the Espionage Act. The reporter James Rison of the New York Times was subpoenaed in relation to the case, and Rison faced a whole lot of losses in the various courts when he refused to testify, but ultimately the U.S. Attorney General decided that the testimony was not necessary, and so Rison was not sent to prison for civil contempt. So what should you do? What you need to do is you need to determine your news organization's policy on confidential sources. If there isn't one, the Associated Press Stylebook has some general guidelines, and also the Society of Professional Journalists says you need to identify sources when feasible, you need to question the motives of sources for seeking anonymity, and you need to clarify the conditions in which you grant anonymity, and you need to keep those promises. So that, just to review one thing which you probably heard before, on the record means that you can use the information and the person's name. On background or not for attribution, you can use the information, but you can't use the person's name. You have to come up with an agreed upon title or sourcing for that. So sources say, or official sources say, or a Temple University professor says. The more information you can get in using that description, the better. Deep background is a kind of Washington term, which means that you can use the information, but you can provide no source. And off the record means that you cannot use it under any circumstances whatsoever. A lot of reporters and a lot of people get background or not for attribution, which means that you can use the information but not use the name. They get it confused with off the record, which means you cannot use it under any circumstances whatsoever. So there's an overview of what you can do in terms of confidential sources, or anonymous sources as we tend to call them in journalism. My advice, be careful about using them. Also, it's important to realize that the public thinks that there are too many anonymous sources being used. That lowers the credibility of journalism. So, as much as you can, try to do your work without confidential or anonymous sources. Well, that's all for today, and thanks very much. Thanks again to Sid, my able companion and assistant, and we'll see you online. Thanks very much.